then the Constitution does not permit the law to distinguish between them and treat them differently.
The proponents of the ballot initiative in Colorado made the perfectly logical argument that all they were doing was leveling the playing field. And Justice Kennedy said, that's not right. That's not correct.
And Your Honor, it wasn't right. They were doing much more than that. They were essentially opening gays and lesbians to private and public discrimination, and disabling any governmental body from intervening in that private discrimination. As Justice Kennedy emphasized, in common, ordinary day civic life, from banking to hospitals to hotels to common carriers, all the ordinary pursuits of civic life, homosexuals were rendered strangers to the law. They could be discriminated against in these fashions. That is a far, far more sweeping and different thing than simply adhering to the definition of marriage that has prevailed in California and everywhere else since time immemorial. And again, the question comes down to this. Are there distinguishing characteristics relevant to an interest that the state has authority to implement at work in the opposite sex definition of marriage? And if there are, then the courts cannot say that acting upon those distinguishing characteristics is invidiously discriminatory.
Let me ask you a question. That's a terrific response. Let me ask you a question that's meant entirely to be neutral. Is it the preference of the proponents, let's assume for the moment that we conclude you have standing and you're here to argue, you're properly here and argue to defend the proposition?
I accept that assumption, certainly.
Okay. Do you want us to get to the merits of the issue here? In other words, do you want us to sidestep Baker?
No, not at all. And Your Honor, I believe that Baker is binding on this court. And my opening legal point would have been that in fact this is not the first court to take up and deal with the very 14th Amendment issues that the plaintiffs bring here today. In fact, there have been 8 appellate courts, state and federal, who have addressed these issues, and insofar as they relate to challenges to traditional marriage laws, just like Proposition 8, and all 8 of those courts have upheld the traditional marriage laws and have rejected the 14th Amendment claims. And one of those cases, Your Honor, is Baker against Nelson, a Supreme Court case that we submit remains a good law, remains binding on this court.
Well, there are some differences. It was before Romer and Lawrence, and it didn't deal with the subject of repealing a constitutional right that existed at the time it was taken away.
That's a fair point, Judge Reinhart. That is a distinction with respect to the issue as it came to the Supreme Court in Baker. There had not been the earlier period in which the Supreme Court had essentially legalized same-sex marriage. So that is a fair point.
The California court, sir, said that's what the Constitution says.
It said that
citizens, we have to accept that from that moment forward. It was not a matter of pulling rabbits out of a hat or something like that. They said this is what the Constitution says.
Your Honor, that's fair enough. They said this is what the state constitution says. But under the California system, it is the people themselves who retain all the sovereign political governmental power, and they are free to review that decision, to disagree with it, and reverse it. And that's what they did in Proposition 8. And so, Your Honor, we would submit to you that the case came to the people of California the same way the case came to the California Supreme Court on review from a decision from the California Court of Appeals, a lower tribunal. And the California electorate disagreed respectfully with their Supreme Court in a 4-3 decision, and they reversed it. In the Crawford case, I would submit to you, Judge Hawkins, is on the point of this. That was another case where the California courts had interpreted the California Constitution, I believe it was, the California Constitution that they had interpreted to go beyond what the federal Constitution requires. And the people of California decided, we're going to bring it back to the place that is required by the federal Constitution. And the court said, in a state like California, where the people retain the ultimate power of the government.
Well, of course, generally, you can amend the Constitution. That's true. It depends on the subject and what you're amending. And I think that's what Judge Hawkins was talking about earlier. What is it that you are amending, and can you amend that? Nobody suggests that you can't amend the California Constitution, no matter how the court has interpreted it as a general rule. The question is, can you amend something? I'm not suggesting it's a fundamental right for purposes of this discussion, but is there a valid reason to amend this Constitution under the standard that we follow?
Well, Your Honor, I believe that the point of Crawford was that the people are free, essentially, to disagree and reverse their
Well,
Constitution.
not anything, as Judge Hawkins was pointing out. You can't say, he asked you, I think, twice, could you say we're going to have segregated education? We couldn't say yes to that.
No, Your Honor, but that's because the federal Constitution would have outlawed that quite apart from whatever the California Supreme Court had to say about it, and so it wouldn't matter if the people did that before a California Supreme Court decision or after a California Supreme Court decision. If the California Constitution had provided that that there will be, racial segregation, as you suggest, in connection with schools, the federal Constitution would outlaw that, and it wouldn't matter whether there had been an intervening Supreme Court decision from California also outlawing it. The point really is simply this: if Proposition 8 had been enacted before the California Supreme Court ultimately invalidated traditional marriage, if it had been enacted before that, the constitutional case that would come to you is the same as it is coming to you now, with Proposition 8 having been enacted to reverse the California Supreme Court, because under Crawford, the people of California retain the authority to reverse their Supreme Court unless the federal Constitution is violated then and there by what they did. So,
if you're taking away a right from a particular class without sufficient reason, that's to say, using the standard, without any reasonable reason, and it's done for a reason that could only be directed at a class in a manner that is, I don't want to say invidious, but in a biased manner. And that you can sometimes derive that view of bias from the action in itself, then you cannot do it. And here, you have to take into account all of the circumstances that Smith mentioned, for instance. You have had all of the aspects of marriage other than the title. What is the reason for wanting to take that title away from a group of people who have enjoyed it? That's where I think you get to the constitutional question.
Well, Your Honor, and our submission to you is that the people of California needed no reason beyond the fact that they disagreed that their Constitution ordained that result, that their Constitution outlawed and invalidated the traditional definition of marriage.
Why isn't that true of Romer also?
I beg your pardon?
Why isn't that true of Romer? The people of Colorado decided that they wanted to do this, and that's what they wanted. That's the way the people of California did. But that there is a limit on that. And it doesn't have to be in the federal Constitution, except that there has to be a rational basis for it, and it can't be related to bias.
Yes, Your Honor, that is true. And so if Proposition 8 was coming to you without there having been this previous period in which California had approved of same-sex marriage, it would come to you in the same constitutional profile that it comes to you now. I guess our point is it isn't changed because there has been this previous period where the California Supreme Court has interpreted the California Constitution to invalidate traditional marriage.
That's an interesting question, I think, in this case. Would it really be the same if the state did not go as far as California had gone? Would they be required to go that far? Or is it different when you're taking something away? I mean, you can argue that there's no difference. And I'm not sure that's a settled question.
Well,
but I would think that the other side, and I know the city of San Francisco particularly did, say it's different when you're taking it away than when you're not giving.
Well, and Your Honor, I am not. I don't deny that there is some force to that proposition, but I do commend to you the Crawford case, which we think does support the proposition that the people, they act. If the California Court of Appeals had invalidated traditional marriage, and the California Supreme Court had reversed that and said, no, our Constitution doesn't do that, no one would say that during the interim that right had existed and the California Supreme Court had stripped the people of California of it. And what we are submitting to you, and we believe the Crawford case supports, is that the people themselves are a tribunal over their Constitution, standing in those types of shoes.
Could the people of California, suppose Proposition 8, in addition to addressing the subject of marriage, had done what in part the proposition in Romer did, which was to disallow civil unions? Would you have the same response? Would you have the same argument?
Your Honor, I believe that the argument I'm making here would be the same, but I do recognize that the argument for the constitutionality of a proposition that accomplished that result, or perhaps I should put it, the constitutionality of that result, would be on different footing than Proposition 8 itself comes to you in.
It's you're a little uncertain if they had added civil unions. What if they had said